Hi everyone, hope that you're all doing well. In this lecture, I want to discuss with you the role of ethics in qualitative research specifically and in sociological research more generally. So here's the plan. We'll talk a little bit about ethics, sort of the institutional legal approach, then we'll actually zoom out a little bit and talk a little bit about the philosophy of ethics. And time permitting, we'll talk in the associated lab a little bit about Venkatesh, who wrote a pretty famous and at this point relatively old work of ethnography that generated an enormous amount of controversy. But it's sort of one in a long line of similarly and similarly controversial and similar ethnographies that illustrate some of the kind of issues I'm going to talk about more abstractly in just a little bit. But let's start with a kind of practical overview of ethics in qualitative research. So you can think about ethics as a philosophical problem. Obviously, formally speaking, it's a branch of philosophy. That's what most people mean when they talk about ethics in a general sense or when they don't qualify it. But it's actually kind of interesting to start with a more pragmatic approach, which is that there is a kind of formal way that we do ethics, so to speak, in qualitative research that's somewhat unique. So even though this is not really irrelevant to quantitative work, there is this kind of well-defined set of procedures that we go through when we do qualitative research, and this is because there are typically fewer direct, formal, and legal ethical issues when we conduct quantitative research. But by contrast, when we do qualitative research, these things tend to come up more often. That said, you can still discuss the sort of ethics of quantitative research if you like, but it requires this sort of more philosophical approach. So let's talk about what that qualitative legal ethical framework is. So basically, the idea here is that from a practical standpoint, the sort of bottom line, people sometimes go beyond this, but this is the minimal approach, is that qualitative research or any kind of research involving human subjects should be reviewed by an institutional review board or IRB, which sounds like a very generic sort of thing, but it's actually a specific institution that I'll talk a little bit about the history of later in the lecture. And note that there are a number of different definitions of what a human subject is, but there's this code of federal regulations that provides the basic working definition. So this is any individual about whom a researcher obtains data through intervention or interaction with the individual, or when they have individually identifiable information. So anytime you do research that has these parameters, you need to submit it to this institutional review board. Now, we're going to pick apart this definition in good sort of legalistic fashion, as befits a lecture that discusses legality a little bit. So what exactly does this human subject business mean? When does this apply? So let's think about the phrase about whom. This means that the focus of the investigation is on the opinions, characteristics, or behaviors of the individual with whom we interact. Pretty straightforward. So what is an intervention or interaction with the individual? This basically means that we've got firsthand data. So are you conducting the study? And remember that one way to think about qualitative research that gets us beyond the unhelpful words versus numbers paradigm is that qualitative research almost definitionally, although not always, but almost definitionally involves firsthand data and typically conducted by the researcher. But in any case, even if it's not conducted directly by the researcher, it's not like a set of observations or questions. We have some kind of access to a person's own words. So you can do an ethnography, for instance, of, let's say, a bodybuilding forum, and you would then still have this kind of direct access to data and potentially individually identifying information. But let's actually define that a little bit more formally. So identifiable private information means that the information about behaviors occurs in a context where an individual is generally speaking going to expect that there's no recording or observation. This is kind of interesting because that doesn't necessarily mean that it has to be private in a proper sense. It could be happening out in public, depending on some people's interpretation. It really just depends on the exact context. But even though it's technically legal to record in a public space in the United States, you could run afoul of this depending on the circumstance because that expectation may not be there. Some more straightforward scenarios would include situations where you're in someone's home or a dorm room or an office or anywhere where, generally speaking, some individual has a legal right to privacy. And another kind of scenario, too, that would fall under this heading would be any scenario where an individual has provided information for specific purposes and expects that it won't be made public. So there's a number of different ways to approach this identifiable private information business, but the main idea is that a situation where a person has a general right to expect privacy and might even have a well-defined legal right to do so, these are situations where we have to run anything by the IRB if we want to deviate from that expectation. So it's kind of worth noting, what does this leave out, or what kinds of research don't fall under this heading, just for the sake of contrast. So research using data that's unlikely to lead you to identify the person in question, which is basically most actual data sets that can be considered quantitative, such as the GSS or the CPS. These could, in theory, include unique information, but it's unlikely that this would work in practice. I'm going to make kind of a brief, just one-line detour here because this is actually relevant to the type of quantitative work I do that deals with some complicated variance estimation methods. So there are some particular scenarios, such as in the use of cluster random sampling, if you can tolerate the callback to the first part of the semester, where in some scenarios, some individual sample weights are very, very large, which means they had a very high probability of inclusion into the sample if they were, say, one of the few people of a minority group from a, census-defined metropolitan area that's in a lowly populated state. So maybe a member of, let's say, a marginal kind of political or religious group who lives in the urban area around Cheyenne, Wyoming, for instance. In that scenario, you could, in theory, possibly make a reasonable guess about who that person is. And so there's actually this statistical technique that has other purposes, but one of them is to help mask information about those people. This is known as replicate weights, so just a kind of interesting topic to worth noting here. But the main point is that this is actually somewhat atypical of quantitative data sets. So let's turn now to the IRB. What really is the IRB, the Institutional Review Board, which some of you may have heard of, and all of you need to conduct some basic training about what these things are. So here's the sort of WIG history, and what this means is the unidimensional narrative of progress. That's what WIG history means generally. I'm giving this here because this is how this is often presented. It's the way that the institution itself presents its history, and it's worth knowing kind of the way people typically think about these things naively, even though it's a little more complicated. So the idea is that we had this bad medical experimentation under fascist rule in Germany, and then we had some, comparable bad medical experimentation under the, under the auspices of the United States, like Tuskegee, for instance, but also the Willowbrook case. And this leads to backlash. So in 1974, the National Research Act, an act of Congress, basically created this set of institutions, one of which the National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research under the Health and Human Services Department, quite a mouthful, issued the Belmont Report, and the Belmont Report is credited with sort of kickstarting a lot of these things. The guidelines contained therein gradually acquired the force of law in the United States, which required ethics review of all human subjects research funded by the U.S. government, and creating the IRB system to carry out those reviews. By the way, an enormous amount of research in the United States is funded directly by the federal government, so even many researchers at the University of Wisconsin-Madison who are employed by the university and technically speaking paid through a combination of taxpayer direct funding and then tuition mostly from in-state students, those people may still get a large amount of money on top of that from the federal government to conduct various types of research. Say, a large part of it, for instance, comes through the National Institute of Health or the NIH. So basically what this means is that very many people are subject to this set of regulations. So that's kind of the potted history that is not necessarily entirely wrong or anything, but largely does exist for the sake of making the IRB look good. It's always a little bit more complicated than that. So if we really break it down and put it objectively, IRB is basically a generic term used by the FDA and the HHS to refer to a group whose function is to review research to assure that the protection of the rights and welfare of the human subjects, but they can be called other things as well. So you can see here, whoops, if we open the, and my link isn't working, we're going to have to go to an alternate source here. Oh, you know what, it wasn't even working on my other setup here. Anyways, it was just a link that describes some of the other kinds of terminology people use. But anyways, these just, can be pretty general sorts of institutions. And some institutions, such as UW-Medicine, have their own IRB and actually even have multiple of them. So you can see here, again, this is going to be a link to the IRB page at UW. They've got a whole website that's kind of hosted at wis.edu. And you can see there's a whole variety of information here, tons and tons of stuff on the website. So it's a pretty detailed organization, obviously. And they have these kind of quasi-legalistic powers. And this is something that we'll kind of talk about and problematize in just a moment. Close this tab here. So just a friendly reminder on this note, by the way, the training that constitutes one component of your final grade, and it's really meant to be free points, gives you some additional information here. So let's turn a little bit away from the IRB and talk about some other institutional legal approaches to ethics. In other words, approaches to ethics where people basically say, here's the set of procedures, we've all decided these are ethical, or these are sort of, to put it more precisely, prerequisites for ethical behavior, and you should basically just go through this sort of step. So a sort of routinized approach to ethics, which obviously is not the only way to think about it. In the traditional conception, ethics is also a very kind of intensely personal and individual question to some extent, and obviously here we're not really focusing on that. But let's turn and talk about those other methods. So there's professional codes of ethics, which play a different regulatory role. For instance, because of the IRB being in some respects what people might call bad law, doesn't mean that the organizations are bad, but they do something that, bad law is actually kind of a technical term. It basically means some organization has a quasi-legal approach to something, but does not have sovereign power to actually enforce law. And this tends to lead to inconsistent and, generally speaking, ineffective action. So sometimes people also turn to the professional codes of ethics to get a sort of bearing on how to act ethically. For instance, here's a snippet from the ASA Code of Ethics, which was part of the reading for today, that outlines some general guidelines for how people ought to act ethically. You can see here professional competence, integrity, professional and scientific responsibility are among the sort of things mentioned in the document. I'll highlight some more relevant portions in the next set of slides, or the next couple of slides here. So you can see confidentiality is a little bit more specific. The stuff on the previous slide, this is kind of boilerplate. But if you're looking for more specific guidelines, confidentiality is typically held to be one of the linchpins of ethical behavior for a sociologist. What confidentiality really means is that basically you're making sure that research subjects have, within certain limits, we'll talk about those soon, an expectation that is fulfilled by you that you protect their private information. And again, what counts as private information, I'll mention an interesting kind of case here that we've already seen in a moment, is going to vary, but this is the general idea. And you can see I highlighted a couple of interesting points here. This is held to be the case even if there is no legal protection for this approach. So even if you, for instance, are you don't have a legal right to withhold certain information, the ASA, formally speaking, still suggests that you adhere strictly to this principle of confidentiality. And this is true, for instance, even after the death of an individual, etc. Now you can see here that the ASA Code of Ethics also points up the limits here. I'll just pull this summary up here while I'm at it. So they're, not total kind of zealots about confidentiality here. You can see laws and rules might sometimes limit confidentiality. So the ASA isn't telling people to break the law. It's just saying that you should kind of err on the side of confidentiality in gray areas. but they do stipulate, when information is clearly health or life-threatening to other people, this is, a situation where they sort of are allowing for an abrogation of this kind of somewhat absolute focus on confidentiality. But the main point here is that this is a kind of fundamental and quite specific principle that is not inconsistent with the IRB, but this kind of focus on the researcher almost as like a lawyer in a sense, or having a lawyer's or a doctor's obligation to privacy is something that is kind of unique and certainly debatable approach to what it means to be ethical. It's actually a very interesting paper that I didn't have time to incorporate it into these slides, but I'll mention this. There was a paper recently, for instance, that in economics that managed to basically provide information that could lead to a dox of users of an economics website called Econ Job Rumors or Econ Job Market Rumors, something like that. It's a website that's anonymous. It's a little bit like 4chan in some ways, or Reddit, back when Reddit used to be a bit more of an unregulated place. Basically involves a lot of economists anonymously saying things that are not very PC in many cases. And there was quite a kerfuffle about the, question about whether or not this was, like, some of what was being said on that website was sort of damaging enough that the fact that, you in theory don't have a legal right really to remain anonymous in a certain sense, although it kind of depends. Some people would argue that you do, but the idea was really more when you're posting anonymously on a forum, even if someone in theory could really try hard to figure out from context clues who you are, that most people understand that type of posting to be anonymous, and whether or not someone has a kind of legal problem in identifying you, should economists be going out of their way to identify individuals that post anonymously in these fora? It's kind of an interesting open question, but again, you can see it is the type of thing that's bound to become controversial when there's such a disciplinary focus. That's in economics, but this is also true in sociology. Such a disciplinary focus on confidentiality as one of those central virtues. Another one that I want to highlight here is the principle of informed consent. So another major section of the code. And informed consent basically means, again, you almost want to think about the legal parallels. This is almost like being read your Miranda rights as a research subject, if you like. Essentially, the researcher is under the obligation to remind people that they can drop out of a study at any time, that they're informed of all of the relevant risks, and that the researcher makes this very clear to them. And you can see I'm just highlighting some general principles here. So the summary: participants should have a full understanding of the possible risks and benefits, and this should be explained verbally and in writing. So that's another one of those sort of routinized things where, because it's oftentimes quite difficult to debate ethics, especially among people that are academics and prone to, really in a way, the whole principle of the thing is that you should debate things until they're finally settled. No one's ever going to finally settle ethics. So one thing that the discipline has sort of come to agree on is that this is kind of a box you can check, essentially, that gives you at least the veneer of ethical action. There's some important details here about informed consent that I want to mention. These are more important if you're actually going to conduct research yourself, but I thought it might be worth saying a little bit more about what this actually looks like. So some of you have seen these things before called consent forms. Some of you, I know, mentioned that you've participated in this sort of research, or you as a subject or as a researcher. These consent forms actually have to be quite detailed. They're reviewed by the IRB. You have to hang on to them, so they're kind of like evidence that you've actually done these things. And even in some cases where you've got these signed consent forms that are waived by the IRB, the researcher still, generally speaking, needs to fill out or to kind of comply with this kind of general process of obtaining informed consent. The general kind of theory here is that participants have to be free at all times to choose whether to participate. So researchers not only need to make this clear to them, but ensure that there is no penalty or even perceived penalty for non-participation or withdrawal. You have to work very hard to avoid exercising undue influence. And one part of that, these might seem like, well, duh, of course, but one part of that that's worth considering that's maybe not obvious is that if you have any incentives for participation, for instance, which is actually a big part of a lot of research projects, this should be small enough that it really shouldn't strongly influence someone's decision to participate, which is actually quite hard to do, arguably. So this is something that I think is, an open and interesting question. Finally, one more principle I wanted to highlight, by the way, there should be 5 rather than 3, is the focus on deception in the ASA Code of Ethics. And this is what I wanted to talk about a little bit more. This is kind of at the intersection of informed consent and confidentiality in a way, but it's sort of a separate principle that doesn't, even if you aren't making anyone's information public, and even if you provide informed consent at, well, I guess it's somewhat nonsensical to say you provide informed consent at the end of a study, but you can provide informed consent and not fully let someone in on the details. So deception is a pretty general kind of term that even if you kind of jump through those other 2 ethical hoops, there's still this interesting question of, is it okay to be dishonest with the research subjects at any point in the process? So the general answer that the ASA gives in its Code of Ethics is that deception is frowned upon, but there are certain exceptions. And those are basically if there's a compelling scientific concern, if the risks to potential participants are minimal. By the way, these are all kind of mutually inclusive conditions, so these both have to be present, and participants are debriefed at the end. So what kinds of scenarios would allow for these exceptions? Well, you might think about the case of Diva Peger's work from 2003, where she basically was deceiving potential employers into thinking that the research participants that she trained to go, well, they aren't really research participants, assistants, whom she trained to go out and apply for jobs, weren't actually applying for jobs. And maybe more importantly, these employers or potential employers' decisions, even though they were being kept anonymous, were also being used as primary evidence of like the maybe worst political sin you can commit in the United States, which would be sort of racial bias. So there's an interesting question there of, does this meet these set of criteria for deception being kind of allowed conditionally? I would say that this is very probably meets those standards, but it's kind of, an interesting open question, or it's the type of thing that you would need to debate. So this is kind of a direct quote from the ASA that we don't need to spend too much time on, but it's interesting to take a look at these. Okay, so let's now transition from ethics as sort of a routine type of, not especially deep philosophical thing, to talk a little bit about the philosophy of ethics, which is worth discussing in its own right. So the thumbnail sketch of ethics, and this is a super general overview, but I wanted to say a little bit about this, is that ethics as a philosophy can be split into 2 broad camps. One of these would be the consequentialist camp, which can be seen as a subset of what's known as utilitarianism, or utilitarianism can be seen as a subset of consequentialism. It doesn't really matter too much. The basic principle here is that actions should be, generally speaking, judged by their overall consequences. The primary counterpart to that would be the deontological approach. What this is quite complicated in general, but broadly speaking, this suggests that ethics is the product of a rational will. In other words, there are some, and maybe even a better way to put it, is that there are certain types of actions that are simply unconditionally unethical, or certain types of principles that one ought to live by that aren't necessarily judged by whether or not, for instance, they lead to, say, like a general decrease in happiness or utility, which is kind of a stuffy formal way to talk about it, but that's how consequentialists generally think, that there are certain actions that might be most ethical that still lead to an overall decrease in happiness. when you really think about it, both of these approaches kind of gesture at the consequences of certain actions, but the consequentialist approach, generally speaking, stipulates that an overall increase in happiness is the primary thing to focus on, or an overall increase in people's enjoyment of life or flourishing. Whereas the deontological approach says that certain types of outcomes, for example, like let's say murder, is more or less, and when I say murder, I mean murder as opposed to, say, execution or some kind of legally sanctioned killing, but murder as in a lawless killing is always wrong, even if, it helps someone feed a starving family, and maybe the starving family has got, maybe you murder a very wealthy person and you feed, Robin Hood style, 1,000 people. There are, or at least this is not necessarily the only deontological position, but if you take the position that that would be wrong simply because murder is categorically wrong, even if more people are, spared like an early death in this way, that would be a deontological position. Whereas the utilitarian position would, generally speaking, say, well, we have to weight up, how much do people benefit from being able to live longer, healthier lives as a result of this murder. Here's kind of an interesting little comic. This is something that has become kind of an internet meme. I typically don't post memes, but this is one that's pretty kind of circulates on the internet. It's really funny. It's actually someone advocating utilitarianism. So the cartoon character is saying, my bike got stolen. I was pretty bummed about it, but I think whoever stole it was probably more happy to get it than I am sad to lose it. The total happiness in the world increased, so whatever. So obviously, this can seem like something of a naive position, and I'm personally not a strong advocate of utilitarianism for this reason. I'll mention a little bit more about a very sort of intuitive counter-argument to this, but I wanted to just establish from the outset what these terms mean. So one thing that's kind of tricky about the intersection of philosophy of ethics and the kind of routine approaches to ethics is that sometimes these routine approaches somewhat haphazardly mix different positions. So let's consider, just as an example, the Belmont Report, which mixes both such positions. So for instance, the Belmont Report advocates respect for persons, so treating people as autonomous and honoring their wishes. Generally, this is a deontological position. It's the idea that there are certain limits beyond which you cannot push people, regardless of the consequences of doing so for some other set of people. The Belmont Report also stresses beneficence, or in other words, that you look at the risk-benefit profile of your research. This is a more consequentialist point of view because it suggests that maybe the research would be super damaging to certain people, but if it's incredibly beneficial to others, maybe it's worth the risk. Whether or not you come down on one side or the other in a given situation, this whole approach is consequentialist. And then finally, there's this general emphasis on justice in the Belmont Report. Basically, you ensure that the risks and benefit of research are distributed fairly, and you could even argue that this whole focus on justice itself constitutes some kind of third branch of ethics, or is a focus that isn't well captured by the deontological or the consequentialist approach. That said, if you had to put it in one camp, it's closer to the deontological camp. So this is another sort of source of complication. So looking a little bit further at the respect for persons bit of business here, and thinking about what this would mean in context and also how that intersects with the philosophy here, treating people as autonomous and honoring their wishes basically means the following if we try to turn it into something routine. Voluntary participation, informed consent, and the avoidance of deception. These can all be considered, pardon me, elements of the routinized approach, which are kind of concerned with this sort of absolute right and wrong. So people are autonomous agents, and then they have certain rights that, generally speaking, shouldn't be abrogated. But we can also see elements of the sort of beneficence emphasis in different aspects of these kind of routinized approaches. One thing that's worth noting here is that the consequentialist approach, generally speaking, leads to ever more debate, because it's a kind of emphasis that stresses that there's some kind of complex and precise moral calculus that should be considered every time with every unique research project. And so this approach is behind a lot of the very thorny debates that have kind of arisen from these recent controversial ethnographies, and also in general a lot of politically controversial research, like what I mentioned before with the Econ Job Rumors website. These, generally speaking, are kind of fomented by the consequentialist approach because it stresses that there's, again, some kind of precise answer that you can come to, but only by weighting up a very complex set of benefits and downsides. And there's this kind of further problem, too, that it's quite difficult usually to measure these costs and benefits. This is the classic utilitarian dilemma. How do we measure utils? And util is it's actually a serious term, although a lot of people find it somewhat risible, because it's just kind of obviously no one's ever seen such a thing in their life, and there's no way of knowing. But utilitarians, because their position really requires that you be able to quantify every cost and every benefit of any action, there's only really one comparable currency, so to speak, that could apply so generally, which would just be a made-up currency like the util. There's also this problem I alluded to before of the utility monster. So should there be limits on what actions are allowable? The true utilitarian position would be no. You should just add up the costs and benefits. But the problem here is that what if someone, for instance, is a true sociopath who experiences just this absolute kind of highest form of benefit from the suffering of others, and they have some kind of superhuman ability, not even superhuman ability, let's just say they have a very exaggerated set of emotions, which is actually true of many sociopaths. The utilitarian position doesn't really have an obvious way to say, well, even though this really sick person gets off on murder, we really shouldn't respect that. Murder is just categorically wrong. And that position really has to appeal to the idea that for most people, actions that are gruesome and offensive to the sensibilities would also be like a very cheap form of pleasure, or wouldn't actually be pleasurable to such people. The utilitarian position has a difficult time dealing with the existence of evil, I would say. I'm obviously kind of biased here a little bit. I, generally speaking, am much more in the deontological camp. But that said, it is worth noting that this type of logic is behind a lot of the debates in qualitative research about the costs and benefits of certain types of research studies. Just for emphasis, I'll kind of mention that the deontological approach would, generally speaking, say that there are certain things that should always be granted to research subjects, and you can occasionally test those limits, but that, generally speaking, you should come up with a set of criteria that you think all research subjects deserve on some level, and then stick by those principles. So it's typically a simpler approach, but it's important to be aware of both of these approaches. So that's where we're going to wrap up today. Thanks everyone for watching. This isn't meant to be obviously a totally comprehensive overview of ethics, but it's meant to give you a sense of what ethics means in the routine sense, the overall philosophy that to some extent underpins these things, but also the messy interaction between philosophy and the sort of rote approach to ethics. Thanks for watching.